Advanced Private International Law. And please read what I posted on the screen so that I could know that you are with me and I am with you. Both are traveling the same boat and to reach the destination. Please read what I posted on the screen. Anyone can unmute and read. Yes.
What are the different classification of laws?
Yes. I think your voice is could not be audible to me. Okay, I will read. What are the different classification of laws? Because generally, laws are classified as a private law and public law and so on and so forth. But when you come to the matter of the private international law, then we can make it how the classification comes over there. So with the disputes or comes, the classification goes in this way. Either the tort or a breach of a contract or matrimonial issues or transfer of property, so on and so forth in the private international law. But one thing that I would like to make it very much clear that generally, read, anyone can unmute and read, generally, yes? Anyone can unmute and read?
Generally, classification of rule of laws applicable in private international law case will depend basically on the ultimate reasoning of a judge. There is no hard and fast rule on this.
Did you get the point? Any point? Did you find it? Okay, I will give the explanation because classification of the rule of law. Here, classification in the sense whether which law could be applied over there depending upon the case which is filed in the Lex 4E, that is the forum. For instance, if the case is filed in Tanzania, then Lex 4E is the law of Tanzania, that is the choice of law. But here, when the rule of law applicable in the private international law case will depend basically on the ultimate reasoning of a judge. So at the time when the dispute was there between the, for instance, take Tanzania and Kenya, and the case is filed in the Tanzania, at that instance, to give the justice to the party, it is the discretion and the reasoning of the judge. He can replace the Tanzanian law and he could use the law of the Kenya. In other words, Lex 4E will be replaced by the Lex Loci because that is the good reasoning to give the justice to the party. And that is the reasoning of a judge to apply which country law could be applied over there. So you want to say it is based on the merits of the case, how the case should be there, so that the parties which comes to the court, they should not go with the empty hands. And the party who comes to the court, they should be justified, and justified in the both the sense, the justice should be given and it seems to be given. So those are the things should be there. And there is no hard and fast rule on these. It is a discretion of the judges to use either the law of the forum or the law of the loci or the different country law. That is the gist of the private international law. So that is the rule. So I want to make it very much clear to you where the judges use, which law can be used over there when there is a case, even though it is filed in the Lex 4E, that is the law of the forum, for instance, to take is Tanzania. So now let us go to the point, because yesterday that we are discussing about the foreign law, and where we said even the person who won the case also cry, weep, even the person who lost the case also cry. And what are the reason I have given? Can you explain? Anyone? Yes? Unmute and give me the answer. Participants,
Hope I wasn't heard.
speak. Speak.
Please repeat the question. Please repeat the question.
Yes, yesterday that I told you, when the case is going on, especially the civil case, which takes a long time, at that instance, the party who won the case also weep, and the party who won the case, he weeps in the house. A party who lost the case weeps in the court. This statement I made it. What did you understand? Hurry up. If you know it, you give me the answer. If you don't know it, you can say pass and I will give you the answer.
It is a win-win situation.
Repeat.
It is a win-win situation. Both parties are satisfied.
No, I will give the answer to you. Especially in the private international, such a situation will not arise. But only in the civil cases, it takes a lot of years, especially the land disputes are concerned. Suppose if any case is decided in the 25 years, do you know that how much the amount will be spent, how much the time will be taken over there? And both the parties, those who are went to the court, they becomes paupers, or in another sense, they will become insolvent or they lose the money. And the only the thing is, a person who won it and he goes to the no, a person who won it, he goes and weeps in the house because he lost the money, he lost the time, he lost the youth, and there is no meaning of winning after the 30 years. So he weeps in the house. And the person who lost it, and he also lost the money, he lost the youth, and he lost the time, and all other factors, and that's why without stopping, he weeps in the court only. But the both are the loser. So the best settlement is, yes, the best settlement is through the negotiation, arbitration, litigations, or combination of all these. In the sense, in one way, in another way, settlement is the best judgment. Repeat. Repeat.
Settlement is a
Settlement
best
is the best judgment.
Do you agree?
Yes.
It is must. One should have to agree it because they cannot waste the time, they cannot waste the money, they cannot waste the youth, and the tension would not be there, and the life would be the free and now miserable, and the longevity of a person will be increased. So let us come to the why do we study the private international law? I already told you that private international law regulates the rules and the jurisdiction. That the courts of which country or the countries will resolve the case. Because generally the private international law is a cross boundary where one of the parties from the other country. So the application of law is governed cross border situations where the judgment of the court in the or one country will be recognized and enforced in another country. In sometimes we will take the judgment as it is and we will follow in the other country. For instance, I will show you the point where I want to show you this thing. Just a minute. See, and you have seen Chacha versus the United Republic of Tanzania. Have you seen on the screen? Say yes.
Yes.
Peter Joseph Chacha versus United Republic of Tanzania. This is the case law. Actually, the administrative case law, it is a human right violation because he was put behind the bar in the Arusha prison against the article of the constitution, and he said the human right violation would be there for his illegal arrest. Actually, that is the thing. So he appealed to the human rights courts and African Charter of the Human Rights Courts. He made it up the appeal. And do you know that there they have considered the case of Indian case? I will show you. I will highlight it here. It is a Chandra case they cited. Why I can make it out from directly here. See, according to the respondent in the same cited case, Supra, the Court of Appeal of Tanzania also quoted the decision of the Indian Supreme Court in the case of Ramesh Chandra Agrawal versus Regency Hospital Limited, 2009. That is the ninth volume, Supreme Court cases, 709 page. See, this is a persuasive value that you can make it out. Then you can say that if it is a real judgment would be there, then definitely the court of Tanzania will take it as it is and they apply in their own case law. Are you following me?
Yes, Professor.
It is called recognition and enforcement of the foreign judgment. So that's why I would like to, I have come across it, that's why I have shown you here. So now let us see that is private international law is a part of international law. Then yes, we already said that public international law versus private international law, and public international law governs the relationship between the two nations, sovereign nation, where the private international law is deals with the private international deals with the private international deals with the, please say.
Private relationships across national borders.
It is across national borders between the two parties. That is the only. What is the private industrial example? Private law is the concern with both the substantive and procedural law governing relationship between the individual, and that the characterization is whether the dispute is a law of torts or whether the dispute is a private injuries or contract or a property disputes or wills, inheritance, marriage or divorce or adoption and the like. That is called the classification, the rule of law in another way. So we already studied the classification, but in the another sense, we will say the same thing, the cause of action. Suppose if you happen to see the syllabus is concerned, yes, I will show you the syllabus also. Advanced private interest. Yeah. So here I happen to see the syllabus. Yes, first is private international law or conflict of laws that we did it. Foreign law, of course, almost are completed. Domestic nationality registrations we completed. Cause of action. Can you tell me what is meant by cause of action? Anyone? Yes. If you know it, you tell me. If you don't know, you say pass on. Don't waste the time. Yes?
Pass.
Yes, why you are taking so much time to say pass on, not pass. P-A-S-S pass, space on, pass on. That is the way. So,
Pass on.
means what applicable law should be, what is the characterization of the case, and which is the rule of law could be applied over there. Whether the Lex Fori or Lex Lucy means other country law. So two way we can make it that is called cause of action. So we already studied this classification, but we did not study in the based on the cause of action. But we already studied it. Now what is cause of action? The classification of the cause of action means allocation of the question raised by the factual situation before the courts is the correct legal category. What legal category is there? That means what type of the dispute is there. That is one way. Whether the dispute is law of tort, whether the dispute is contract, whether the dispute is matrimonial issues, whether the dispute is regarding the property. That is one of these classification. The another rule of law is of the cause of action. It says the cause of action also shows which country law could be applied over there to give the justice to the parties. It is the discretion of the judge. I already told you which country law could be used over there. Even the country of the law can be replaced by the country of the another country because that is the justice to the party and it is the discretion of the who? It is the discretion of the, yes? It is the discretion of the, please tell me. It is the discretion of the judge. It is the reasoning of a judge. He can replace even the local law and he can use different country law to give the justice to the parties. That's why I told you there is no
Fast
There is no
rule on
hard
this.
and fast rule on this.
There is no hard and fast rule on this case. It is depends upon the merits of the case law. That is actually the thing which I want to make it out here. So actually I should be doing the plagiarism if I don't endorse the courtesy Issa Kimaro, and he is editor-in-chief and a founder of the SharianJamai.com, and he is the holder of the Bachelor degree of Mzumbe University, and he did the postgraduate legal practice for the Law School of Tanzania, and is a practicing lawyer, and he developed this blog. From there, I tapped the information regarding the what is classification in the private international law. This already we covered it, but still we should see in the cause of action angle. We should see in the cause of action angle. So in a private international law, is a civil case or a criminal case? Anyone? Yes?
Civil. Civil case.
It is a civil case. So the private international law case is a civil case involving the foreign element, technically known as the conflict of laws. But we will say in the American, we say the conflict of laws because the Britishers, UK, that we don't use the word conflict of laws, but we will use, please fill up the blank.
Pass on.
Private international law. We don't say the conflict of laws. It is the other country, USA and other countries say, but predominantly the UK will use the word private international law. So the trial court will have to determine whether it has a jurisdiction both over the parties and the cause of action. So now the jurisdiction is the main point, whether this court is having the jurisdiction to entertain such a case or not. So naturally, the court will give the discretion to the plaintiff because plaintiff should not be suffered and plaintiff will be given a pure justice, and justice, and that to be at the no cost, no time basis, the justice should be given to the plaintiff. Hence, we can say forum convenience will be used in the plaintiff. What is meant by forum convenience? Yes? What is meant by forum convenience? Forum convenience. Yes. Please, if you don't know, say pass on. I will give you the answer. Don't waste the time. Yes?
Pass.
Say, don't say pass. Pass on. P-A-S-S pass, space on. O-N on. Don't say pass. Okay, now I will give you the point. Here, the court will determine the jurisdiction, whether this court is having the jurisdiction or not. But generally, plaintiff will not be suffered a lot. Where the plaintiff stays, suppose the plaintiff stays in Tanzania. Let he will file a case in Tanzania only. Even though cause of action dealt or happened in Kenya. Are you following me?
Please repeat.
See, one of the party is Tanzanian. The another party is Kenyan. There is a breach of a contract. Happened at the, what do you say, what is the connecting factor? Lex loci actus, where the law of contract made over there. Law of contract made where? Kenya. At that instance, actually the file should be filed in the Kenya because breach happened at the Kenya. But the parties, one of the party is in Tanzania. A Tanzanian cannot go and file a case in Kenya. Hence, the private international law give the such a facility to the party, means plaintiff, and who got the breach, and a breach happened in the Kenya by another party who is from Kenya. At that instance, court will give the discretion to the plaintiff. If you want to file a case, you can file also in Tanzania. That is called forum convenience will be given to the plaintiff. So the plaintiff will not suffer to go Kenya and for each trial. He can file in the Tanzania and the case will be entertained in the Tanzania. That means the jurisdiction having the Tanzania for the forum convenience to the plaintiff. Is it clear? Is it clear?
It is clear,
Yes.
bro.
Now let us see the cause of action. Where the breach have happened? Where the breach has occurred in this example? Where the breach has occurred in this example, where the one party is from the Tanzania, another party is from the Kenya, and it is a breach of contract, and the contract is concluded in the Kenya. Breach occurred in Kenya.
Kenya.
So cause of action actually at the Kenya. But case is filed in Tanzania because of forum convenience, the option is given to the plaintiff. The plaintiff should not suffer. So cause of action is happened at the Kenya. Now, what about the cause of action? It's a breach of a contract. Now, what is the choice of law could be used over there? That is the secondary aspect. When the case is going on over there, now, if the Tanzania law is used over there for the breach of a contract, at the time, and the plaintiff will get the less compensation or less amount for as a damages. But if the Kenyan law could be used over there, and the plaintiff will get the more damages, so the court will take the discretion and replace the law of the Tanzania and use the law of Kenya to give the justice to the party. What justice to the party? The damages awarded if they follow the Tanzania law is low or less. The damages awarded the Kenyan law of the breach of contract is more. Hence, more benefit will be given to the plaintiff. That is the sole motto of the judges in the private international law. So it is then, what do you say in the terminology? Lex Fori will be replaced by the Lex Loci. That means law of the forum, which is the choice of law of the Tanzania, will be replaced by Lex Loci, means where the cause of action happened over there in another country. For example, Kenya, Kenyan law could be replaced in the place of Tanzanian law to give the justice to the party, because the justice to the party where the damages are more, if the Kenyan law would be followed, if the Tanzanian law would be followed for the breach of contract, the damages are less. At that instance, court take the discretion and follow the law of
The law of Kenya.
Law of Kenya. I appreciate. Why? This you have to remember. What you have to remember? Generally, classification of rule of law applicable in the private international law case will depend basically on the ultimate reasoning of a judge. That means it is a discretion, it is the reasoning of a judge. to replace the law, to use the jurisdiction, even though the cause of action happened in the Kenya, but jurisdiction is given to the plaintiff because the plaintiff is from Tanzania. For convenience also given by the court to the plaintiff. So what we say, there is no
There is no hard and fast rule on this.
Yes, so in this case law, in this decision, in the private international dispute, there is no hard and fast rule would be there. But the only justice is, the justice should be given, will be made, and that to be seems to be made, but not in contravention with the local existing law of Tanzania. Not in contravention or against the existing law of the Tanzania, including the Constitution of Tanzania. Repeat. Repeat. A foreign law could be used over there in Tanzania to give the justice to the party, provided that law, that is a Kenyan law, should not be in contravention with the existing law of the Tanzania, including the Constitution of Tanzania. Repeat. Sir, we don't know, sir.
The law of Kenya will I let me just how I understand the law of Kenya, if it would not contravene with the law of Tanzania, it will stand. But if it contravenes with the law and the constitution of Tanzania, then it will not stand.
Why
All
the
the
law of
statutes
Kenya
of
could be used in Tanzania?
foreign law.
Why foreign law could be used in Tanzania?
If it is consistent with the law of Tanzania, then the foreign law will stand. But if it is not, it will not stand.
You are giving the answer, but you are repeating.
There is no hard and fast rule on this.
But you are giving the answer, no doubt, but you are beating around the bush. The reason is to give justice to the parties, to make the justice, and justice should be seems to be done, and it is to be done. At that instance, Lex 4E will be replaced by Lex Loci, that is Tanzania law will be replaced by the Kenyan law to give the justice to the parties, those who are in the dispute. It is the reasoning of the
Judge.
It is the reasoning of a judge. And hence, there is no hard and fast rule on this point. Is it clear?
Yes.
Yes. Now, yes, that is the point which I want to make it out for the foreign law is concerned. And the question of the cause of action, as I told you that, yes, it is nothing but the classification. What is meant the classification? Number one, classification of a dispute. That means classification of a dispute or characterization of a dispute. That means, tell me. If you know it, you tell me. If you don't know it, you say pass on.
Pass on.
That means whether such a dispute is law of contract, law of trust, marriage, divorce, adoption, succession, or transfer of property. That is the number one classification. Number 2 rule of law is which country law could be used over there. Whether the law of the forum or law of the loci, where the cause of action happened. Now let us see the meaning of classification. This is again repetition, I told you. This is again the repetition, but we will see the cause of action angle. At the time we saw the classification angle. Now, classification in terms of the private international law, that is nothing but characterization in the terms of the private international law is the selection or classification of cause of action. It is nothing but classification of the cause of action and rule of law. What is the cause of action? Categorization. What is meant by categorization? Whether the dispute is a start, whether the dispute is contract, whether the dispute is a matrimonial issue, whether the dispute is property. That is one cause of action. Is it clear?
Yes.
The next is the rule of law applicable. The rule of applicable law to the dispute where the involving the foreign element, of course, when there is no foreign element, it is not a private international law. The rule of law applicable to the dispute involving the foreign element means which country law could be used over there, whether the Lex Fori law or the Lex Loci law. That is called the causation and the rule of applicable law to the dispute involving the foreign element. So two aspects are there. One categorization is whether it is a dispute of contract, tort, matrimonial issue, or property issue. That is one way, classification or characterization. Another characterization is a rule of law. Which rule of law applicable over there? Means what law can be applicable over there? So how many laws are there generally? One is Lex Fori law, means law of the forum, where the case is filed. Suppose the case is filed in Tanzania, then Tanzanian law is one law. Is it clear?
Yes.
Suppose the cause of action or the breach of a contract or matrimonial issue or the law of tort or any accident happened in the Kenya. The cause of action happened in Kenya. Hence another law is
Lex Lucy.
yes, but Lex Loci we can say Kenyan law. That is a Kenyan law, Lex Loci. So how many laws are there now here? How many laws are there here?
Two
What are
laws.
they?
Lex Fori and Lex Lucy. Law of the forum and law of the country.
No, law of the cause of action, where the cause of action arises, that is called Lex Loci.
Law cause of action. I'm sorry.
Yes, that means that where the case is filed, Tanzania, where the cause of action arises, there in another country, Kenyan. So Kenyan law and Tanzanian law would be there. Now, which law could be applicable over there depends upon the nature of the case, number one. It is the reasoning of a judge, number two. If he wants, he can replace the Tanzanian law and use the law of the Kenya. At that instance, we can say Lex Fori will be replaced by the Lex Loci to give the justice to the party because the reasoning of the judge is like that. Hence, we can say there is no hard and fast rule in this regard. Is it clear? Now, this means allocation of question rights by the factual situation before the court its correct legal category. In the process of classification, the court required to analyze the pleading prepared by the parties and to assign each component element to the most appropriate judicial concept of category. So it depends upon how a judge will be convinced by the counsel of both the parties. Depending upon that one, judge will take the discretion to use which country law could be used over there. Number one. And when you use it, I already told you that if another country law you use it in Tanzania, but that another country law should not be the contravention with the existing law of the Tanzania, including the constitution of Tanzania. So the rule of any given system of law are arranged in the different categories addressing the procedure, that is a status, there is a contract, a tort, a divorce, nullity, and so on. That is one categorization. And how do the court use the classification in conflict of laws? Read. How do the court use the classification in the conflict of laws? Read.
When courts faced with a case of the foreign element have a two-stage process. First, the court will apply the law of the forum, lex fori. Lex fori means the domestic law of the court dealing with the case, to all procedural matters including evidence rules and choice of law rules.
Yes, it is a general practice that because there are two laws are there. One is procedure law, another is
Substantive law.
substantial law. Can you give the one example for the procedure law and one example for the substantial law?
Penal Code and Criminal Procedure.
Easier? Easier?
Penal code is a procedural law. Criminal procedure and civil procedure code are considered to be substantive law.
Cosa. K-O-S-A. Reverse, you told.
Penal Code is a substantive law and Criminal Procedure Act is a procedural law.
You are right. Criminal Procedure Act and Civil Procedure Code, including the law of evidence, sometimes law of limitation, these are said to be the procedure laws. When the matter comes substantial law, even the constitution is a substantial law. Of course, it goes with the both. But the penal code is a substantial law, and the law of contract is a substantial law. And at that instance, where we can say rights and duties are there, where the compensation will be awarded, where there is a breach of such a contract. That is a substantial law is concerned. So generally, when the case is filed, the procedure law is lex fori. What are the substantial law? It depends upon the choice of rule of law, whether the case is filed in Tanzania or the cause of action arose in the Kenya. At that instance, it is the reasoning of the court to decide which country law could be used, either the Tanzania or the Kenya. If Kenyan law would be giving the more justice to the plaintiff, at that instance, Tanzanian law would be replaced by Kenyan law. At the time, choice of law is Kenyan law. That is the rule of law. So, that is the thing which we want to make it out. When you come to the matter of the again, yes, cause of action is concerned, the same thing will be going on. Again, further the High Court to account the factors of the connector or the link of the legal status to the law of the potentiality relevant to the states and applies the law that have a greatest connection. What is meant by greatest connection? Where the law could be applicable over there. The greatest connection means the justification to the parties, whether the Kenyan law could be used over there or the Tanzania law would be used over there to give the justice to the plaintiff. That is the greatest connections would be there. Now let us see the example. The law of nationality, lex patria we will say, or the domicile, the lex domicili. What is this lex patria, lex domicili, lex loci actus, lex loci solutionis, lex loci contract, lex loci delicti? What are all these things? Yes. Lex citus. What is all those things? If you know it, you tell me. If you don't know it, you say pass on. Yes. Please, don't waste the time.
Laws of potentially relevant states.
No. These are all lex patrial, domicili, lex contractus, lex loci solutionis, lex loci delicti, lex locis actus, even a renvoi. These are all connecting factors. I will give you a detailed study of the connecting factor and the unification of the private international law in a one separate class. These are all connecting factors also plays an important role in private international law to use the which country law could be used over there. Generally, for the movable property, what is the connecting factor? Movable property, what is the connecting factor? For the immovable property, what is the connecting factor? If you know it, you tell me. If you don't know it, you say pass on.
I'm going to try, Prof. Lex loci actus.
For what? Lex loci actus is for what? Is it for the movable property? Is it for the immovable property?
For the immovable.
Cosa. Immovable property connecting factor is lex situs. Where the property is situated. That is called lex, L-E-X, lex space S-I-T-U-S, lex situs for the immovable property. For the movable property, what is the connecting factor? Yes. Lex domicili. What is the connecting factor?
Lex domicili.
For the law of, what is the connecting factor?
Could you repeat?
For the law of tort, what is the connecting factor?
Lex situs.
It is for the immovable property. For the law of
Lex patria.
no. For the law of tort, lex loci delicti. What is the connecting factor for the law of tort?
Lex loci delicti.
Delicti, where the damage, where the incident, where the thing happened in that country law is having the most close connection for the law of tort. For the law of marriage, what is the connecting factor? For the law of marriage, what is the connecting factor?
Lex loci actus.
Lex loci celebrationist. Celebrationist. Lex loci celebrationist. That is the connecting factor. So we will deal the separate class connecting factor and unification of the private international law. So here the capacity of the party for the immobile property is lex situs, for the mobile property is lex domicili of the plaintiff or the person where the case is involved over there. So law of the state in which the land is situated is lex situs will be applied to determine all question of the title. So for the immobile property, what is the connecting factor?
Lex situs.
I appreciate. The law of the place where the transaction physically take place or the occurrence that gave rise to the litigation is the law of contract, that is lex loci actus. Where the contract occurrence is happened over there, the connecting factor is lex loci actus. Will often be the controlling law selected when the matter is substantial. So that is the thing. The process of classification in private international law. How a process of classification takes in the private international law. Generally, the process of classification involves the two things, namely classification of cause of action and the classification of the rule of law. What is the classification of the cause of action? Yes? Just before I told you, there are two factors are there to determine in the private international law. Number one is classification of the cause of action.
Lex fori. Lex fori and
No.
lex loci.
No. The classification of the cause of action means the nature of the dispute involved, whether it is a law of tort, whether it is a law of breach of contract, whether it is the divorce, whether it is adoption, whether it is a inheritance, whether it is a property dispute. That is called classification of cause of action. What about the next thing? What about the next thing? Classification of the rule of law. Now you tell me what is the classification of the rule of law? Just before I explain. Choice of law. Classification of the rule of law is nothing but only 5 minutes are left. Please tell me. If you don't know, you say pass on, I will give the reply, answer. What is meant by classification of rule of law? Are you hearing me? Dorcas, Macmillan Lema, Raymond Cosmas. Are you hearing me? All the three, are you hearing me? All the three, are you hearing me? No one is giving the reply to me. That means you could not hear me. But anyway, that doesn't matter. I will give the explanation because it is a recorded one and you could hear it. So when you come to the classification rule of law it is nothing but whether the lex fori could be used over there as a to give the justification to the party, or lex loci could be used over there to give the justification of party. In the sense, whether the dispute between the Tanzania and Kenya would be there, whether the Tanzania law would be used or Kenyan law would be used to give the justice to the party is said to be the classification of the rule of law. Is it clear? Is it clear? Okay, because I think there is